Well, kings, queens, gods, human beings, and everything in between, welcome back to Flesh of the Gods. The God Shango here. Today, we continue our journey into the heart of the justice system's inner workings. We've witnessed the tears of a grieving family, and we've analyzed the testimony of Officer Amy Detweiler, a key witness that helped lead the guilty verdict for Adam Coy in the murder trial of Andre Hill. Today, we peel back another layer. We now face a new form of deception, one cloaked in expertise and credibility. We turn our attention to former Officer Kevin Davis. Davis was once a SWAT team lead instructor, training officer, officer here, officer there, SWAT, all types of stuff. This is a man who also taught police the very rules of engagement, and he was brought in as a paid expert witness. But here's the truth that cannot be ignored. Kevin Davis was paid $250 an hour for this case. That's right, family. I said $250 an hour. And his sole purpose was to justify the unjustifiable murder of Andre Hill. He was a hired gun for the system, basically. Seems to be brought in to create a legal shield for a convicted murderer who, to this day, still believes his actions were justified and is appealing his guilty verdict. This episode isn't just about a trial. It's a re-examination of a system that will spend thousands of dollars to defend a lie. We will watch and analyze Davis' testimony, questioning the very definition of expert, as in their expertise is for sale. What kind of truth can be found when it comes at an hourly price tag? But before we begin, remember that all the video and audio clips used are part of the public record and are used for the purpose of analysis and commentary. If this journey into the truth resonates with your spirit, please like, subscribe, tap in, and share with a friend. Stay vigilant, stay fresh, and stay blessed. Let's get it started, family.
Well, isn't this a nice surprise?
Clearly indicates an expert witness cannot get in otherwise evidence that has not yet been admitted. And here in this case, this testimony and statements of the defendant have not yet been admitted into evidence. If they're going to use that information and come up with their analysis and give their conclusions of whether conduct fell within generally recognized police practices, that is fine, but I believe it would strictly prohibit the admittance or the use or the production of his testimony and his statements to the jury before those underlying statements have been in themselves been admitted into evidence. I believe the court referenced, possible med-mal cases where, you have experts talking about things that are otherwise hearsay, and I don't obviously contest that, but I would argue and hypothesize that those documents had already been admitted into evidence. There's probably stipulations on both sides that the documents have been admitted into evidence, and therefore that expert can then talk about the specific content.
Before we get too far, let me say what up to the first ones in the chat. What up, what up, what up? No one, I see you, family. Brown Sugar Babe, what up, what up? Chad, my black is golden. Much love, and late night bacon with Mookie. I see y'all, family. Appreciate y'all joining.
Of those documents, even outside of giving their overall opinion. Here, it's different. Here, the defendant's statement is not in evidence. So for an expert to get up there and say, I read in Officer Coy's statement X, Y, and Z. He said X, Y, and Z. I interpreted that to mean this based on general police practices, that's appropriate or not appropriate. I think that is outside of the rule. I think that's outside of what the case law has clearly indicated is permissible. The case law that we have researched has found that this is it's outside of the discretion. The expert is only able to testify about things, perceptions gained from direct personal examination of the defendant or facts and evidence admitted at the hearing. Here we don't have that. Thank you, Your Honor.
The
I have an additional item. That's
Okay.
Brown sugar babe, I said game, not gang. No,
like for me to wait and address these issues separately, or?
No, go ahead and make your argument.
Thank you. With respect to
Daniel Berry Sports Highlights. What up, though?
the measurements, again, talking about the experts, we had a discussion before. The court had excluded certain photographs that the defense was attempting to maybe use with their expert. The state also feels that, especially since those pictures were prohibited from becoming used in this trial, we also request and make a motion in limine that the experts aren't allowed to do those things on the stand. I believe there was a measurements taken through the witness, Asia Chung, who was a crime scene search unit. The state would object to any of those types of activities happening with an expert on the stand. Again, that is outside the scope of the report. The case law and the rules clearly state that experts are only allowed to testify to things that are contained in the expert report. None of the experts talk about measurements. They just make a general statement that, cool.
So pretty much what he talking about right now is he trying to exclude the expert testimony. This officer that's about to come up and talk, he trying to get it thrown out. The dude that's on the cover, he don't want him to testify, but you already know how that's gonna go, because this is what the show is about. This episode is about him, so you know he gonna testify.
The defendant's interpretation of the keys could be interpreted to be a revolver. That's it. There were no measurements taken or anything like that. Again, the state would have done and could have done things differently had that information been contained in the report and there were going to be measurements taken and comparisons taken from that standpoint. So the state would object to an expert witness on the stand making those sorts of measurements as well. Thank you.
All right, thank you. Any response?
Your Honor, very briefly, with regards to the duplicate, you've already ruled on this. I'm not sure why we're arguing this again. The court's already ruled on it and indicated that we can, and if it becomes duplicative, you will steer us off of those issues. So, I mean, the court's made a ruling. Same with regards to the third thing, Your Honor. You said the exhibits don't come back. However, any demonstrations that an expert wants to do, you're going to allow them to do. I mean, it's demonstrative. Experts are always asked hypotheticals. Experts are always asked about demonstrations. And, if we want to do that on the stand, you've already indicated, Your Honor, on a previous ruling that we're allowed to do that. With regards to the order, again, Your Honor, the experts are sent a long time ago statement by my client, written statement by my client, and all the evidence. They have to review the packet of discovery that the government has. That packet of discovery is sent to the experts. They base their reports on that. So they're basing their reports on information that my client gave and things of that nature. They could put that in the first case. They can call their expert in their case in chief. They chose not to, Your Honor. So I guess I'm not sure where this is coming from now. We have a burden in this case to try to restrict our order of presentation of material is not genuine with regards to we can't restrict their order and things of that nature. If they wanted to call their expert in the case in chief, they could, Your Honor. That's happened in several cases in police shootings that we had. It happened in front of Judge Young with Andrew Mitchell, Your Honor. The government put their expert on their case in chief. They get to choose because they have a burden as well. They get to choose whether they put that on in their case in chief or a rebuttal, Your Honor, depending on the burden that they so to speak. So, you gave us guidance on Friday, Your Honor, and, for scheduling purposes and things of that nature, and it was off the record. And I understand why the need to address on the record for the protection of the record, but we would ask that you follow the advice that you gave us on Friday, Your Honor.
Okay. Any response?
Yes, Your Honor. I argued this on Friday without having the rule in front of me. Now I have the rule in front of me. And now I think it's important that we follow the rules that have been laid out. And Rule 703 clearly states, yes, the state could have done a lot of things, but we chose not to put his statement into evidence for strategic reasons. And yes, experts rely on this information. I'm not saying that it should be excluded entirely. I'm just saying that if they're planning to ask the witness, their expert witness, and have that verbalized to the jury, those things need to be admitted into evidence prior to them doing them. I'm just asking the court to follow the rule. That's all I'm doing. Thank you.
Your Honor, if I may.
You may.
I can't admit my client's statement, Your Honor. I can't admit his written statement. I can't admit his taped interview. I'm precluded from doing that by the rules of evidence. So it's a situation, Your Honor, in which cross-examination, if our client says something different than his statements, they're allowed to cross-examine on him. They can't cross-examine an expert on our client's testimony in court versus what he said in his statement versus what he said in his written statement. They're not allowed to do that because we have a separation of witnesses in the state's cases, and experts in state cases can't sit in during the testimony. In federal court, they can. That's why they're allowed to do that. So again, he indicates about admitting. I can't admit my client's statement in our case in chief. I can't admit his tape recording. So the experts have nothing to do with his testimony if he testifies and so chooses to testify, Your Honor. So basically what Mr. Pearson's saying is if our client doesn't testify, then no experts can testify. And that's just not the case in these types of cases, Your Honor.
Okay, thank you. Okay, as to the duplicate experts, I think when we had discussion before, one of the reasons that the court ultimately overruled the state's motion, I mean, the state has had the expert reports for, I don't know, years, I guess. And we're getting ready to start the trial, and it's at that point in time that the state then makes a motion to exclude one of the experts. Now, the court did indicate if both of the experts are essentially testifying as to the same thing, the court will accept any objections at that particular time and may exclude certain testimony from one of the experts, depending on the duplicate nature of that. But the court has already ruled that the defense can present the two experts. As to Evidence Rule 703, I mean, 703 indicates that an expert can base their opinion on facts or data. Hold on. Personal knowledge of the facts or data underlying his or her opinion. That knowledge is a permissible predicate for his or her testimony. It does also indicate that an expert could base their opinion upon the testimony that is presented. But in this case, and again, the example says, for example, an attending physician who treated an injured plaintiff would have firsthand knowledge of the facts which could permissibly support expert opinion testimony as to the permanence of the plaintiff's disability. In this case, the expert is aware of the supporting data by reason of her or her firsthand experience. Again, they're basing their testimony on documents that were received, or I guess treatment of the plaintiff that occurred prior to the trial. You wouldn't need the plaintiff to testify as to what happened to them for the expert then to come in and opine. Again, the expert's testimony, and I'm assuming both experts, well, both sides' experts are testifying based upon information that was provided to them prior to court. I think it would be, well, it would be left to further objections if the defendant testified and then the expert offered an opinion different than what was presented earlier based upon testimony in court that is contrary to what the experts reviewed. Obviously, if the defendant does testify contrary to what's in the report, then that's open for cross-examination and potentially inconsistent statements, which potentially could impact the weight that the trier of facts give to the testimony of the expert witnesses. So the court does not believe that it's necessary for the defendant to testify first in order for the experts to offer opinions. Obviously, they're going to need to get into the record what they're basing the information upon which they're basing their opinions upon. Well, all the experts will need to do that. And that's the information that was provided prior to trial.
Of course, we know he gonna let him in.
As to the expert getting on the witness stand and presenting measurements, again, the court does not have any issue with the experts doing so. Now, the experts, to my understanding, did not offer any opinions in their report as to what those measurements would mean. They cannot come into court today or tomorrow and then say, based upon the length of the keys, we have an opinion. The court would consider that impermissible. Obviously, either side can argue what that means, and it would be up to the trier of fact to decide whether or not they find any significance whatsoever to the length of the keys to what the defendant alleged that he believed that he saw. So having the expert do the measurements, again, court has no issue with that. Experts can't offer any opinion as to what those measurements may mean because no opinions were offered before. And part of the reason that the court excluded the defense from using the photographs was because of the fact that the court found those to be staged and the photographs would be difficult for the state to be able to cross. But with the witness attempting to make the measurements on the stand, the witness would be available for cross-examination. So the motion is denied. All right.
Well,
Denied.
we knew that was coming. What up, Joni 4? I see you, family. Appreciate you joining. Y'all drop some Blue Jays in the chat for Joni 4.
Anything else for the record on behalf of the state?
Not on the record, Your Honor.
Okay, on behalf of the defendant? Okay. All right. Excuse us a moment. Counsel, please approach off the record.
So let's get into it. Here's the testimony of Officer
Denied.
Kevin. What's his name? Kevin something.
Do you swear or affirm that the testimony that you're about
Kevin
to give is
Davis.
the truth, the whole truth, and nothing but
think-
the truth, as you shall answer unto God under the pains and penalties of perjury?
Retired Officer Kevin Davis. I think his last name Davis. I don't know. I'm trying to look at it, but it's not in my title.
All right. It's important that you speak into the mic so that the ladies and gentlemen of the jury can hear you. All right. It's also important that you respond verbally. Sometimes it's difficult to interpret.
Understood, thank you.
For the record, if you would please state your name, spelling your last.
Kevin, R as in Robert, Davis, D-A-V-I-S.
You may inquire.
Thank you, Your Honor. Good morning, Mr. Davis.
Good morning, Counselor.
Can you tell the jury a little bit about yourself?
Well, I'm a retired law enforcement officer from 1982 till 1990. I was a deputy sheriff with the Summit County Sheriff's Department. County seat is Akron. From 1990 until I retired in 2021, I was an officer with the City of Akron Police Department. I worked a variety of assignments in the Sheriff's Department, Corrections, Uniform Patrol. And then when I transferred over to the Akron Police Department, I worked Uniform Patrol, transferred into Street Narcotics, and then began working for the Training Bureau, where I was a full-time trainer for about 18 years. Collateral with that, I was a member of the Akron Police Department SWAT team, where I was a team leader and lead instructor for the Akron Police Department SWAT team.
You said you're retired. How do you like being retired?
I'm busier now than I was when I was working.
What do you do for a living now?
I'm a consultant and a trainer and expert witness. I run my own business.
Oh, you talked about
He run a business as an expert witness, $250 an hour.
the various assignments and positions you've held throughout your career. How long have you been in law enforcement?
Well, as a police officer or deputy sheriff, 39 years. And then since I retired in 2021, I've continued to work in the field, so somewhere around 45 years.
Thank you. In order to become a law enforcement officer, Mr. Davis, did you go through the Ohio Peace Officer Training Academy?
I was agencies, 25th office, Ohio Peace Officers Training Academy.
What
When I left the Akron Police job,
have you authored any articles on nationally recognized police practices?
yes, I was a freelance writer for about 15 years. I worked for all the major law enforcement periodicals, Police Magazine, Law Officer Magazine, Law and Order, Tactical Response, a variety of different periodicals.
What are some of the topics that you've authored articles on?
All this training and you don't know how to speak into a microphone?
With respect to those periodicals?
Primarily on my topic area, use of force, firearms and tactics.
Are those articles that you've authored relied upon by other experts in your industry?
Yes, I'm sorry. ILETA especially, I publish in the Journal, which is their online newsletter to ILETA members, which go out to all law enforcement trainers in the organization.
Thank you, Mr. Davis. I want to talk to you about your training with respect to use of force and how it relates to human factors. Do you examine human factors when analyzing a use of force?
Yes, this is a kind of a growing subject area, and since I've been in law enforcement, it has increased in the scientific research that's been applied, as well as our understanding. Basically, human factors are the relationship between the human being, the officer in this case, or others it can be, but as they relate to the outside world, to stimulus, as well as internal things like how the body functions under stress, our understanding of time and distance, et cetera.
Have you yourself reviewed studies on human factors
Oh, yes,
and as they relate to uses of force?
that's correct.
Have you yourself developed coursework with respect to human factors that you have since trained other officers on?
Yes, over the years, as I said, that's increased tremendously.
Can you tell the ladies and gentlemen of the jury why that specifically is important?
Well, it explains many things, everything from how far.
Yeah, they volumes is super off, so I'm trying to keep it balanced as much as I can for y'all. Hopefully it sound okay. Appreciate y'all being here. What up, Miss D56? I see you. Appreciate you joining.
A subject can cover a certain amount of distance to how the eyes work under stress and in low light conditions, to our understanding of how the body works. What we used to call fight or flight is really our understanding of sympathetic nervous system reaction, or how the body reacts to stimulus when it feels fear.
You mentioned to the members of the jury ILETA. Do you belong to that professional organization?
I do, yes.
Have you ever received any awards or been recognized in the field of use of force?
Yes, in 2018, I was the recipient of the State of Ohio Attorney General's Distinguished Training Award, and in 2019, I was inducted into the National Law Enforcement Hall of Fame as Trainer of the Year.
Thank you, Mr. Davis. Do you take continuing education with respect to law enforcement topics?
So look, typically I would skip past all these accolades because, you know, all they accolades don't usually really matter. But I wanted to play all this stuff that he claiming that he did, all this training and all his accolades that he have, and abuse of and excessive force and all that stuff. And then he gonna sit here and say that this officer that got convicted of murder did not use excessive force by killing this person. That's crazy. So how are you training people? How you have all this training? What type of training do y'all have?
Oh, yes.
Why is that?
Well, as I said, the field is advancing tremendously, and in order to stay ahead of the topic area, you have to go to training conferences and seminars and learn learn the newest research, et cetera.
Understood. You mentioned earlier that you own a consulting business. What does a consultant do?
A variety of different things. Help agencies develop policy and procedure, consult with law departments for different cities, look at situations or incidents and review them for agencies and consult on whether that, in my opinion, is a good use of force or within the law, or use of force that's outside of the law, as well as provide expert testimony in those cases.
And have you done all that with respect to your consulting business?
I have, yes.
And how long, sir, have you owned your own business?
In one form or another, more than 25 years.
Have you testified before as an expert in nationally recognized police practices?
I have, yes.
How about use of force?
Yes.
What about in municipal court?
Yes.
What about in common police court?
Throughout Ohio, everywhere from Colga County to Scioto County, throughout the state.
How about federally, sir?
Yes.
Have you been declared an expert in those various courts that we just discussed?
I have, yes.
Have you testified in other states?
Yes, a variety of states from Colorado through Georgia.
And have you been declared an expert when you go to those other states with respect to law enforcement and use of force?
I have, yes.
Your Honor, at this time, the defense moves to qualify Mr. Davis as an expert witness of nationally recognized police practices.
So for those of you who just tapping in, this is the case of Adam Coy right here, the officer that shot Adrian Hill. Hey, that's not his name. Andre Hill, the one that shot Andre Hill. My fault. I'm horrible with names, as y'all know if y'all watch me. But yeah, so he shot Andre Hill, this guy right here, in the garage, unknown officer. He was already convicted. This is the third day of trial. We played the conviction and all that, so if you want to get caught up, we do have the first and second day and the conviction when he was sentenced, his sentencing. He was sentenced to 15 years to life. So yeah, we do have that as well, but that's for y'all who don't know. Appreciate you.
Objection, Your Honor.
All right. The record shall so reflect.
Thank you, Your Honor. Mr. Davis, I want to talk to you about the general process that you follow when determining to take a case as a consultant. Is there a process?
There is, yes. It varies in complexity. For instance, this case, the amount of material that was delivered to me was in a 1 terabyte external drive. It was a very large file.
So what is that process that you typically go through for determining whether or not to take a case outside of information?
Well, everything from the initial response or the nature of the call as developed. What I try to develop is what's called totality of the circumstances, or the total picture that the officer was involved in at the time of the use of force.
Have you reviewed cases on use of force and decided not to take them as a consultant?
Yes, I have.
Why is that?
They, as I said earlier, they were outside the legal standards, in my opinion, of what an officer could or could not do.
Based on your review of information, do you form a basic opinion?
I do, yes.
And as information continues to trickle in, do you continue to evaluate and assess your information and compare it to what your original opinion may have been?
Yes.
Are you paid for your time, sir?
I am.
How much are you paid for your time?
$250 an hour in this case.
Is that industry standard?
experts charge.
I want to turn now, Mr. Davis,
Hour in this case,
how much are you paid for your time?
$250 an hour in this case.
Is that industry standard?
It's cheaper than a lot of experts charge.
I want to turn now, Mr. Davis, to discuss this case.
That boy said $250 an hour. That's what they charging to come and testify for the state. So the state is paying that. That's taxpayer money that's paying for that.
Case. Did you follow the same process that we just discussed with respect to this case here at hand?
I did, yes.
When was the first time, or just generally the first time, that I made contact with you about this case?
Well, I believe it was early 2022. You know, the exact date I'm not sure about. Somewhere before May, I believe.
And did you get you the initial material that you needed to come to an opinion in this case?
Oftentimes in discovery, I get the case and the material comes in, as the counselor said, in a trickle form. And I did not receive the terabyte drive until September of 2022.
In that terabyte, did you receive all of the information that you needed to come to an opinion in this case?
I never testified that I received all of the information. That's dependent on others, but I did review the information that was provided to me.
And it was enough to form an opinion for this case?
That is correct.
What specifically did I ask you to do, sir?
Review the material. We first provide an oral opinion, and then if we go forward, then a written report is commissioned, and I go about preparing a written report.
And did you prepare a report based on the information that was provided to you in this case?
I did, yes.
Would it assist you, sir, to have your report in front of you while we discuss your opinions to refer back to it?
Please.
May I approach the witness, Your Honor? That I am approaching the witness with what has been previously identified for identification purposes only as Defendant's Exhibit 11 and 12.
Well, isn't this a nice surprise?
Or VT.
11 is?
This is my CV or curriculum vita or vitae. It's basically a legal resume, my background.
Now, we went over, we just highlighted some of those portions of your CV for the members of the jury, but that's certainly not all of your all of the qualifications. Is that correct?
That's correct.
What about Defendant's Exhibit 12, sir? Can you tell the ladies and gentlemen of the jury what that is?
This is my written report that I did in preparation for this case.
And was that the written report in its entirety? You were flipping through a lot of pages there.
It is, yes.
Is it a fair and accurate copy of the report that you submitted as a consultant in this case?
It is, yes.
Mr. Davis, did you come to an opinion in this case?
I did, yes.
Now, before we get to that opinion, I want to talk about how you came to your opinion and the authority that you used to come to your opinion. Specifically, sir, what did you base your opinion on?
Well, the legal standards as they apply to police officers and use of force, the real guiding legal standard is Graham v. Connor, but there are other legal standards, Tennessee versus Garner, State v. White in the state of Ohio, and other lower court decisions.
You're naming cases. Why are you naming cases, sir?
That's what's taught to basic academy cadets and in-service officers in the state of Ohio. And these are the legal standards that apply to the officers in the performance of their duties, specifically when we talk about use of force.
So is that the methodology you use when determining an opinion?
That's the basic, because that forms the foundation for the use of force. And then other issues, we talk about human factors and other issues that I involve.
Now, you talked about the parameters, and you mentioned a case called Graham v. Connor. What are the parameters by which Graham sets up for experts to review a use of force?
Well, Graham was the first time that the Supreme Court looked at the use of non-deadly force. Prior to that, Tennessee versus Garner looked at police use of deadly force. So those two cases are pretty much hand in hand. The Tennessee versus Garner case applied the Fourth Amendment, as did the Supreme Court in Graham. And what that means is that they consider use of force, whether non-deadly or deadly, a seizure. And because of the seizure element, the Fourth Amendment applies, and the standard for that Fourth Amendment is objective reasonableness.
Have you heard of the Graham factors, sir?
I have, yes.
Can you tell the ladies and gentlemen of the jury what the Graham factors are?
This is a non-exhaustive list, as they say in State v. White, but it's the severity of the crime at issue, how severe the crime is, whether there was an immediate threat posed to the officer or others, whether the suspect was actively resisting arrest, and number 4 was the suspect attempting to flee arrest.
Now, you mentioned State v. White. Why are you talking about State v. White, and what's its significance here?
Well, there's several different. It was the first time that the Supreme Court looked at Graham v. Connor and applied it to a criminal case in Ohio. Throughout courts that I've testified in throughout the United States, some courts don't apply Graham v. Connor because it was a civil case, and they said it doesn't apply to criminal cases. In State v. White, they applied the Graham standard in Tennessee versus Garner, the objective reasonableness test, to all use of force within the state of Ohio, deadly or non-deadly. And more importantly about this case is that the State v. White involved a subject who was shot by police officers who did not have a firearm.
So was that officer mistaken in State v. White?
Yeah, he was.
And what do nationally recognized police practices say about an officer being mistaken?
Well, it's tough when we talk about national police standards because there's roughly 18,000 different agencies within the United States and about 800,000 officers, less than that nowadays, so that there is no set standard. But when we apply the constitutional standards, those are across the board throughout the United States.
And what do those standards say about whether an officer is allowed or not allowed to be mistaken?
Objection, Your Honor.
All right. Excuse us, ladies.
It means they could clearly lie to you. They tell you they can lie to you, and they always lie to you because that's what they wrote into the book.
Ladies and gentlemen, counsel, please approach.
That's all that means, mistaken. What you mean mistaken? You mean you was lying? Is the officer allowed to lie is the question? Crazy.
This is the process.
You may.
Thank you very much, Your Honor. Mr. Davis, if you recall, we were talking about mistake. Do you train officers with respect to mistake?
Yes, that's part of the decision-making process, and unfortunately, as the Supreme Court said in Graham v. Connor, that officers are oftentimes forced to make decisions in circumstances that are tense, uncertain, and rapidly evolving. So yes, that officers can and do make mistakes.
So with respect to this case, sir, did you come to an opinion of whether or not Adam Coy's use of force was consistent with nationally recognized police practices?
I did, yes.
And did you use the same principles and methods that we just talked about in coming to your conclusion as you do in every case?
I did, yes.
And is your opinion, sir, based on a reasonable degree of professional certainty when it comes to whether this use of force is in fact consistent with nationally recognized police practices?
It is, yes.
And what is that opinion, sir?
That Officer Coy's use of deadly force at the moment that it was used was what a reasonably prudent and well-trained officer.
Objection, Your Honor.
You see that, Mr. Super Trained, well trained, 10, 20, 30 years training, SWAT officer, sheriff, and all that extra shit, and then you gonna sit here and say it's in alignment, it's okay for him to kill people. That's what you saying. This is what y'all train and do. It's part of y'all training for y'all to kill people for no reason. Why? How, Sway?
Come on back just for a second. Excuse us again, ladies and gentlemen.
That's that bullshit right there. That's that bullshit right there, for real. That's they training. They trade to kill niggas. That they and talk about they protecting or defending their own life, knowing that's some bullshit.
Well, kings, queens, gods, human beings, and everything in between, welcome back to Flesh of the Gods. The God Shango here. Today, we continue our journey into the heart of the justice system's inner workings. We've witnessed the tears of a grieving family, and we've analyzed the testimony of Officer Amy Detweiler, a key witness that helped lead the guilty verdict for Adam Coy in the murder trial of Andre Hill. Today, we peel back another layer. We now face a new form of deception, one cloaked in expertise and credibility. We turn our attention to former Officer Kevin Davis. Davis was once a SWAT team lead instructor, training officer, officer here, officer there, SWAT, all types of stuff. This is a man who also taught police the very rules of engagement, and he was brought in as a paid expert witness. But here's the truth that cannot be ignored. Kevin Davis was paid $250 an hour for this case. That's right, family. I said $250 an hour. And his sole purpose was to justify the unjustifiable murder of Andre Hill. He was a hired gun for the system, basically. Seems to be brought in to create a legal shield for a convicted murderer who, to this day, still believes his actions were justified and is appealing his guilty verdict. This episode isn't just about a trial. It's a re-examination of a system that will spend thousands of dollars to defend a lie. We will watch and analyze Davis' testimony, questioning the very definition of expert, as in their expertise is for sale. What kind of truth can be found when it comes at an hourly price tag? But before we begin, remember that all the video and audio clips used are part of the public record and are used for the purpose of analysis and commentary. If this journey into the truth resonates with your spirit, please like, subscribe, tap in, and share with a friend. Stay vigilant, stay fresh, and stay blessed. Let's get it started, family. Tat in the building, what up though? Tat Clouds, FFS in the building, what up though? I see y'all, appreciate y'all joining, family. Sweetie! Yo, shout out to Tat and FFS. I see y'all, appreciate y'all, family. We gonna get back into it. Keep it rolling. Part 2. After they lunch break, we back here now. I fast forwarded. Got it lined up for you. Appreciate y'all. Let's keep it going.
Jury.
Adam Coy's use of death.
All right. Ms. Stevens, if you rephrase.
Thank you very much, Your Honor. Sir, your opinion in this case is that Adam Coy's use of deadly force is consistent with nationally recognized police practices. Is that correct?
That is correct, yes.
I want to talk about how you came to that opinion. What exactly did you examine first in coming to the opinion that his use of force was within nationally recognized police practices?
Well, I think I first reviewed his statements and his partner's statement, Officer Detweiler's, and then worked from there.
And what did you first determine? What did you first look at in order to determine whether or not Adam Coy's use of deadly force was consistent with nationally recognized police practices?
Looked at the nature of the call, Officer Coy's responses, the decedent, Mr. Hill's actions and responses in dealing with Officer Coy, and then went into the body-worn camera evidence.
Did Officer Coy have a lawful objective for taking action here?
Yes, he was dispatched to a disturbance call, but the nature of the call was actually a suspicious person called in from a neighbor.
Sir, can you tell the ladies and gentlemen of the jury what it means when I say reasonable, articulable suspicion?
Yes, it's a legal standard in policing. There are different, there's like a timeline of officer-subject interactions. Everything from consensual stops. An officer is wanting to talk to somebody, but doesn't have anything more than, I like to find out who this person is. And that's a consensual stop. If you say, "Excuse me, sir, can I talk to you?" and he stops, that's a consent. It may develop from there into reasonable, articulable suspicion that a crime has been, is being, or about to be committed. And then from there, that may develop into probable cause to make an arrest.
Is reasonable
The absence of evidence is not the evidence of absence.
What?
You see how they do it. They got it all lined up and figured out to make sure they can slide in however they want to. Big shout out to Joni for it. Y'all drop some Blue Jays in the chat. Drop some coins in the chat. Go crazy. Show her some love. Appreciate the support, family. Y'all show her some love in the chat. Let's keep it rolling.
Articulable suspicion a nationally recognized police practice?
Oh, yes.
What is an officer trained to do when they have reasonable, articulable suspicion?
Well, there's a variety of different responses that an officer can use, but an officer can detain a person. That would be what's called a Terry stop. Based on reasonable suspicion, you can stop the person. From there, it may develop into a Terry search or pat down of the outer garments for weapons. That comes from Terry versus Ohio. So, as I said, it's based on articulable suspicion that a crime has been, is being, or about to be committed.
If an officer has a reasonable, articulable suspicion, do they have to investigate?
That's an officer's obligation to respond to the call and to develop the call, to investigate, and to interview the person as a reasonable suspicion is developed. Then yes, they would have an obligation to deal with the subject.
So did Adam Coy have a reasonable, articulable suspicion in this case?
I believe so, yes.
Why is that?
I believe the decedent Mr. Hill's actions developed, based on everything. That's totality, the circumstances, the time of the morning. It was after 1:35 in the morning. The fact that a neighbor called in and said, "Hey, this is a suspicious vehicle, was idling here, turning on and off, and then moved up in several spaces on the street and parked." And then, based on the responses of Mr. Hill to the contact, everything from leaning out of the window and showing his cell phone to going up to the house, banging on the door, no one responded to the door, and then going back, leaning into his vehicle, and then going back towards the house. So all of that combined is totality of the circumstances, which, once again, would lead to reasonable suspicion.
What kind of reasonable suspicion does a trained officer observing these things have? How is an officer trained to perceive these actions?
Well, there's everything. The subject's demeanor, nervousness can be one. Mr. Hill was described as being fidgety and wide-eyed, and from his behaviors and showing the phone as if blocking the interior of the SUV was driving, going up to the house, knocking loudly on the house, and saying he was waiting for someone and no one came to the door.
Yo, check out Tat Tat Tat. Got the new logo, the new symbol. What's that? Got the new pic. I'm gonna have to zoom in. I can't really see what it is.
Lights came on, coming back, leaning into the vehicle again, and then going back up, towards the house where Officer Coy lost sight of him.
So did Officer Coy have to stay and observe what was going on?
Yes, that would be prudent police work.
Would that be consistent with nationally recognized police practices?
Oh, yes.
Okay, I want to talk about the timing of this event, sir. Did you analyze the timing of this use of deadly force?
The actual application of the use of deadly force, the entire call as it transpired from the body-worn camera that was turned on by Officer Coy, and then yes, as to the amount of time of the deadly force encounter.
Do you examine how quickly events transpire when analyzing a use of deadly force?
Time is an issue, especially when an officer doesn't have time to make a step back and make a reflective decision or take other steps. In other words, if the subject or suspect creates what the Supreme Court said is tense, uncertain, and rapidly evolving, the higher that is, then the more stress is placed on an officer in making decisions.
And did you find that these circumstances were rapidly evolving and tense and uncertain?
Yes.
You mentioned you analyzed the body-worn camera. Can you talk the ladies and gentlemen of the jury through the timing of the body-worn camera with respect to the approach and approaching Mr. Hill in the garage?
Yes, I was a detective in the body-worn camera unit of the Akron Police Department for the last 3 years of my career, and I analyzed thousands of hours of body-worn camera video. The states supplied some expert work on the video, which put what's called a timeline on the video so you can track the elapsed time, also a frame counter, but they did brighten the video. So you have to remember that that's not what Officer Coy saw. Furthermore, the camera records at a higher light level than the human eye, so that's not what Officer Coy saw. But yes, when you look at the motions by the raw body-worn camera video as well as the OOIC video with the timeline, I did analyze that, yes, and the time involved.
So, could Adam Coy have walked away as he was approaching up from the drive?
I'm sorry, could Officer Coy have walked away?
Correct.
That's not what we expect of police officers. You call an officer to investigate these types of circumstances, and that's their responsibility to handle the call. So no.
Sir, how long in your analysis does it take from the time Adam Coy illuminates Andre Hill in the garage until he brings his pistol into view?
As Mr. Hill is walking towards him, there's roughly about 3 seconds that transpire from the time that Mr. Hill begins to move until we can see the pistol come up into the frame of the BWC.
At the time he used deadly force, Mr. Davis, should Officer Coy have asked additional questions?
See, the problem with talking in those types of circumstances is, as human beings, we're not very capable of doing multiple things at the same time. For instance, when you pull up to an ATM, you turn the volume of your stereo down. Why? So you can attend to the ATM, you can focus. As human beings, we do the same thing. When we talk, we're thinking about talking or challenging or giving verbal commands. In that, we slow our reaction or response time when we talk. So verbal commands, if Officer Hill felt threatened with death or serious bodily injury, were not required.
What do nationally recognized police practices train an officer in with respect to perceiving a deadly threat?
That deadly force is appropriate. A variety of other options could be used, for instance, moving, but if the officer perceives that his life's in danger, then deadly force is appropriate.
And that's with regards to nationally recognized police practices?
That is correct.
You mentioned earlier about the Graham factors. Did you analyze these in coming to your opinion that Adam Coy was in fact consistent with nationally recognized police practices?
I did, yes.
What are the Graham factors again, sir?
Like I told you, they training is to kill. They paid they licensed to kill for real. No doubt about it.
First of all, the severity of the crime, and these aren't necessarily in the order some of the lower courts have said. The next one, the immediate threat to the officer or others, is the paramount thing. Severity of the crime, whether the subject is actively resisting arrest or attempting to evade arrest by flight. But that's not an exclusive list.
I understand. I want to take those factors one by one, however. You talked about the severity of the crime at issue. Tell the ladies and gentlemen of the jury what you mean by severity of the crime.
Well, severity of the crime is not what the original call was. In this case, it was a disturbance call or a suspicious person, suspicious vehicle. That's not the severity of the crime. The severity of crime is at the moment the officer uses force. For instance, an officer can be trying to arrest a jaywalker in the downtown area, and the jaywalker pulls a gun on the officer. The severity of the crime is that action, the attempted murder or felonious assault of the police officer.
Is there any more severe of a crime than when a suspect levels a gun at a police officer?
Other than being shot at, no.
How do national police standards teach officers to respond in that situation?
Once again, in these tense, uncertain, and rapidly evolving circumstance where they fear that their life or the life of another is being threatened with death or serious bodily harm, then deadly force response by the officer is appropriate.
Do national police standards mandate that an officer have to be 100% sure before responding with deadly force?
No, unfortunately, what we were talking about is something called action response time. When a subject, for instance, with a clear-cut gun down behind their thigh or at the low ready or pointing at the ground, if an officer waits until the gun is leveled or the gun is fired, the officer is going to lose because of the response time lag. In other words, I can do this in about 1/3 of a second. That's all it takes for an officer or for a subject to raise and fire at an officer. In truth, just as I've handled cases or dealt with cases where just a shift of the hand, a subject fired at an officer, that was even less than 1/3 of a second.
So are police officers trained with respect to subject reaction time?
Yes, it's a big part. Subjects armed with knives, what they call the 21-foot theory with subjects armed with knives, that they can run 21 feet in about 1.5 seconds, and that's about the time it takes an officer to draw and fire one round.
So how you didn't know it was a knife? How you just gonna assume that it was a gun and shoot at him like he had a gun when you never even saw a gun? Talk about gun. I'll play the video on the side right now.
As is subjects with hands in pockets, hands secreted, anything, anytime that the subject makes a motion, etc. Those are all taught in law enforcement, basic and in-service training.
But sir, we know that Mr. Hill was not armed with a firearm here. Does that matter?
Of course it matters, and it's tragic.
Just moments after Andre Hill walked out of a garage at a house where he was a guest, he was shot by police.
Put your hands out to the side. Hands out to the side now. Roll to your stomach now.
Body cam footage from officers in Columbus, Ohio, appears to show Andre Hill, an unarmed black man, still alive as he lay wounded. Just moments. Just moments after Andre Hill walked out of a garage at a house where he was a guest, he was shot by police.
Put your hands out to the side. Hands out to the side now. Roll to your stomach now.
Body cam footage from officers in Columbus, Ohio, appears to show Andre Hill, an unarmed black man, still alive as he lay wounded on the ground.
I want to move on to the third factor, sir, whether the suspect is attempting to evade. What did you find with respect to that factor?
Well, Mr. Hill was walking towards Officer Coy at that time, but prior to that, it was Officer Coy's statement that he lost sight of Mr. Hill, and they believed that Mr. Hill went around the house to the rear of the house at that time.
So did you find that he was actively trying to avoid arrest or evade detection?
It was rather interesting that Officer Coy stated that he tried to hail Mr. Hill as he walked the second time towards the house, but Mr. Hill just looked over him, didn't respond, and didn't stop, etc.
You talked briefly about the body-worn camera here in this incident that you analyzed. Are there any other limitations for the body-worn camera when reviewing a use of deadly force?
Oh, yes. Unfortunately, based on technology, and we watch TV and movies, we tend to believe what we see, what the camera shows us, but in reality, that's not the human eye. There are limitations to the camera. For instance, these videos were shot at about 30 frames per second, which means that the camera takes pictures, individual pictures, at 30 frames per second. That looks like it's continuous, but really on a camera, the only thing that is continuous is the audio. Everything else is segmented, as I said, 30 frames per second. The camera also distorts images at the edges because it has a fisheye lens. And because of that, there's some distortion. As I said, it's the
What does any of that have to do with this guy sitting there shooting this guy for no reason? What does the lens and the distortion, and when it comes to that, it's all that. But then when y'all got camera footage on somebody else, it's pure and oh yeah, it's the best evidence. But when it comes to y'all act like, oh no, yeah, that don't count. That don't count. I'm an expert witness. We know that doesn't really count.
camera picks up more light than the human eye does, so that doesn't accurately reflect what the officers or officers involved see, especially at night. And then the camera, the digital system, is designed to save space on the drive. So it uses what's called I-frames or B-frames. And what that does is if something in the image, something within the camera doesn't move fast enough, then the camera recreates that same image or recreates portions of it. So otherwise the drive on the camera would have to be huge. So it's kind of an interesting way that the camera works. So we have to understand the limitations. And it also doesn't pick up if an officer is in contact with somebody, doesn't feel what the officer feel, or what we call resistive tension. So there are limitations in the camera systems.
How do you account for those limitations in coming to a conclusion?
Well, the camera is only one piece of the evidence. It's you have to look at the totality of the circumstances, the facts, the evidence as are recovered or discovered.
I'm so high right now, y'all. I'm about to go sleep on y'all now.
In the investigation, you can't just solely rely on the video.
Does the body-worn camera take into account human factors that you discussed earlier?
Oh no. Matter of fact, one of the problems with the camera is that it tends to project images that are actually further away than the camera portrays. That because of the two-dimensional image, it looks closer.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
What human factors did you analyze here in this case?
Well, the biggest part of this case is the aspects of low light and human vision. That's the biggest thing because of the limitations of what Officer Coy could see. And the next thing would be action response time, that once he perceived what he believed was a silver revolver held in Mr. Hill's hand, you know, the time it would take for him to react and respond. So an action, as I said, is always faster than response time.
I want to talk about that second principle. You said an action is always faster than a response time. Are officers trained on this?
Oh, yes. It's become a big part of police basic
That would be
academy
the
and
right
service.
front, the right left, excuse me, the right left side. Front.
Okay, all right.
Oh! Somebody! Oh! He needs some milk!
Training.
Can you tell the ladies and gentlemen of the jury why it's important to take action versus reaction into your consideration when analyzing perceived threats?
The officer's decision to take action, and any decision, is based on the totality of the circumstances. And in a well-lit day out on the sidewalk, on a day like today, when an officer has the ability to see everything or see as much as it can, even then we have limitations with human vision. But with action, as I said, just the pointing of a gun is so quick that an officer doesn't have time. If he is attentive to the subject, then it's going to be the time it takes for him to begin or to download a mental response, in other words, drawing a pistol. Then there's the movement time, the time from the beginning of the draw to the extension of the arm or arms and the press of the trigger. That's movement time. So we put reaction time with movement time, and it's significantly longer than the subject's time to just act.
Do nationally recognized police practices take into consideration threat patterns?
Yes, we teach officers in basic academy to develop a mental shortcut. Now, we can't do that on the range with live fire because we don't have animated targets. We're not that sophisticated. But in the training process, officers are exposed to virtual simulators like FAT systems or Virtua systems that are basically movie screens that the officer responds to and shoots a non-firearm, essentially a laser at the screen simulating gunfire. So we try.
So these niggas learn how to shoot playing GTA. That's their training. They was playing their own version of GTA, a little 3D version with some 3D glasses on. No wonder why they so scary.
And then that's coupled with usually confrontation simulation training, where officers deal with role players that are suited up to protect their face and eyes, and we have non-deadly, what's called marking cartridges, essentially very expensive paint rounds that fire out of realistic firearms, and these are used by role players and the officers.
So how are officers trained with respect to threat identification and threat patterns?
Well, we tried to teach them what it looks like to draw. I mean, this isn't like a gunfight at the OK Corral where the bad guy's got a holstered gun, the sheriff has a holstered gun, and that doesn't happen. So we go off where suspects normally secrete firearms and how suspects on the street act and attack officers with firearms.
How do suspects on the street typically attack officers with firearms?
Usually it's a one-hand point and shoot.
Where is that firearm kept typically?
Well, everything from secreted on the subject, usually the abdominal area, the front of the waistband, but subjects have secreted firearms in their pockets. Officers say, "Excuse me, sir, can you take your hands out of your pocket?" Subject draws a gun and shoots the officer. Everything to hiding the gun behind their thigh or down, trying to obscure the view of the officer. That could be in a car, it can be on foot, etc.
And so when an officer is approaching a suspect who he believes to be armed, is that what they're looking for?
The hands. What we teach officers is to watch the hands, because what's in the hands is what's going to kill or assault officers.
Sir, do you know what perceptual narrowing is?
I do, yes.
What does that mean?
With stress, and there's a variety of different ways the body and the brain and the eyes work, is that we normally have a very wide visual field, but in stress, things narrow down because this over here is not important and this is not important by the brain, so we focus into about a 10-degree arc of vision, and that's perceptual narrowing. The eyes are seeing it, but the brain is not registering it.
So was that taken into your account here with respect to the use of deadly force?
Oh yes, tunnel vision and perceptual narrowing by the eyes was definitely taken into effect or taken into consideration.
Why is that?
Because once again, the officer is focusing in, Officer Coy is focusing in on what he perceives as a threat.
FFS said I'll fire myself. Where I signed up for this, $250 an hour? That's insane for you to get up here and just lie. That's a great job. You could lie. You could just make up shit.
No wonder he
I
retired.
want to talk about the environment within the realm of the totality of the circumstances. You mentioned the low lighting, but are additional environmental considerations taken into account?
Well, this can be, the presence of other potential suspects, violent nature of calls, all that is looked at in an analysis.
With respect to the lighting, sir, what did you find with respect to this use of deadly force?
This is what we would call adverse lighting. In other words, the floodlights at it would be the southwest corner of the house illuminated the driveway, so the officers were illuminated as they walked up the driveway, but Mr. Hill was not illuminated in the depth of the garage.
And I'm not going to do it again this episode, but last episode we broke down this video and we saw him sneaking stuff out the car. The officers helped him get rid of evidence. I don't know if it was pills or cocaine or I don't know what it was, but it was something that looked like wasn't supposed to be there, but they let him get rid of it, it looked like. But yeah, that was in the last episode, episode 2.
Even with the flashlight, very hard to see him penetrate into the darkness to see what Mr. Hill has in his hands or what he's doing.
Did you analyze tactics here?
Yes, always.
What tactics specifically did you examine?
Well, the approach, the way the call was handled by Officer Coy and Detweiler, the approach to Mr. Hill, and then the tactics involved with the actual confrontation.
And did you find that the tactics in this case that were taken were consistent with nationally recognized police practices?
Yes, there are no specific answers. The Supreme Court has said that use of force is incapable of precise definition or mechanical application. What we look at is a range of things. And first of all, this was lawful. What Officer Coy and Detweiler did was within the law in terms of the way they approached Mr. Hill. Then we looked at, do average officers, is this a range of behavior? And it certainly is, in my experience as well.
Have you reviewed the state?
It certainly is. This is certainly in the range of behavior to shoot a nigga for no reason. Really, bruh?
Expert report by Seth Stoughton?
I did, yes.
What did you find with respect to that report?
I know Mr. Stoughton. I believe that he uses a lot of what I call constructs. For instance, he uses opportunity, jeopardy, and apparent intent as a construct to formulate his opinion. And he also focuses on what I would call hindsight bias. In other words, we know the outcome that Mr. Hill had a set of keys in his hand and not a handgun. But Professor Stoughton looks backward and from that hindsight bias makes the determination that the activities of the officer created jeopardy, which led to the shooting.
Is that consistent with nationally recognized police practices, what Professor Stoughton does?
No, officer created jeopardy is specifically precluded in Graham v. Connor because it says that we shouldn't look at officers' use of force 20/20 hindsight. But in State v. White, it clearly says that even the most erudite police practices expert shouldn't count rearward-looking hindsight as to what the officer could have, should have, or might have done.
And why is that important?
Because that's another way for them to get away with doing some bullshit that they know they shouldn't have did. Like, y'all lock people up for stuff they shouldn't have did and look at what they should have, could have, would have done. Why didn't they do this? Why didn't they do that? Why don't y'all do that with police officers? That don't make no sense. They're, again, above the law. They always above the law.
Because we're supposed to judge an officer's use of any force from their perspective, not what Mr. Stoughton believes based on his office.
You said from their perspective. So whose perspective are you supposed to look at?
Officer Coy's perspective.
And what did you find, sir, with respect to Officer Coy's perspective with regards to whether or not his perspective and his use of deadly force complied with nationally recognized police practices?
I believe that based on his statement that he reasonably believed that Mr. Hill presented the threat of death or serious bodily harm, and that the use of deadly force was within the standards in law enforcement.
Even though he was mistaken?
Even though he was mistaken. Tragically, but even though he was mistaken.
May I have a moment, Your Honor?
You may.
Negative, sir. We contact medics.
I copy.
Get some gloves. You got gloves on?
Yes, sir.
Questions for you at this time.
Start
I'm
pumping
sure
his chest.
Mr. Pearson has some questions for you, though.
It was too late for the
Thank you, Ms.
47-year-old, who became yet
Cross-examination.
another unarmed black man to die in an encounter with law enforcement in America.
Where is the humanity for Andre Hill? Where is the
afternoon, Mr.
humanity
Davis.
Good afternoon, Counsel.
for this Columbus citizen?
Police officers were responding to a non-emergency call from a neighbour over a noise complaint when they encountered Mr. Hill. The white officer, December, is now being investigated.
Andre Hill should be alive today. A Columbus police officer is responsible for his death. I can't defend it. I can't make it right. But I will do what is in my power.
Andre Hill's daughter is haunted, imagining her father in his final moments.
I gotta memorize my dad on the floor for the rest of my life and how nobody helped him. How there's 22 officers on the scene with body footage and not one of them helped my dad.
The family says they won't stop until they have justice for Andre Hill.
Well, isn't this a nice surprise?
Good to see you again.
Nice to see you as well.
You teach use of force curriculum, is that correct?
I do, yes.
Okay. You teach it in various areas, looks like in the Midwest, is that right?
Wherever national conferences are held, it's tended to be in the Midwest, but it can be other places.
You teach this to law enforcement officers?
I do, yes, as well as labor associations, et cetera.
Okay. And you teach, though, in those teachings, you teach officers essentially the law of what you feel it is with respect to officer-involved shootings. Is that right?
Well, I teach them and point them in the direction of the legal standards, yes.
Okay. And you teach them what constitutes a quote-unquote bad shooting, correct?
I don't know that that is a curriculum. I look at what is within the law and what is outside the law.
So you teach these students what is within the law for officer-involved shootings?
I teach them to examine and apply the legal standards to officer-involved shootings, yes.
And you teach them what is outside of the law with respect to officer-involved shootings, is that right?
I think I've covered excessive use of deadly force, so yes.
And you teach them about the various factors that need to be taken into account when deadly force is used?
There's a variety of different areas in that topic.
So do you teach them about those areas?
If you're asking about the Graham factors, or in addition to the Graham factors, yes.
So you teach these officers about the need for a severity of crime, like the need to analyze that?
That's one of the Graham factors, that's correct.
And the suspect actively resisting arrest, you talk to your students about how that's important?
Yes.
You talk to them about whether there's an immediate threat and why that is important in an officer-involved shooting?
Yes.
And what?
And you still say it's okay to shoot somebody. That's still crazy to me. You the teacher of you teach them what to do. So you taught them. You were one of the ones that's saying they supposed to shoot the person. That's crazy. You should be locked up too. That's part of the RICO, right? You one of the head organizers.
Whether the suspect is fleeing or not, you talk to them, talk to your students about the importance of that. Is that right?
That amongst, as I said, many other topic areas. It's not an exhaustive list in Graham.
Okay. You referenced case law in your discussion with the defense counsel. Do you recall that?
I do, yes.
Yes. You're not a legal expert, are you?
No, I'm an expert on the use of force investigations.
Okay, and you've never gone to law school, correct?
No,
Not an attorney, correct?
that is correct.
You rely heavily on Graham v. Connor and State versus White. Those are the two cases that you have mentioned, is that right?
In my testimony,
Yes, in your testimony.
I've mentioned Tennessee versus Garner. There are also a multitude of lower court decisions.
Okay. Do you recall when Graham versus Connor was decided?
Graham was decided in 1989.
Okay, so about 35 years ago. Is that right?
I'll trust your math, counselor.
About 30.
It's
It
fine.
was about 35 years ago, right?
Yes. It's fine.
Okay. Do you know how many cases have applied Graham v. Connor, either applying it, altering it, overruling it? Do you know how many cases have done that?
By the Supreme Court or
Right.
lower courts?
Any courts?
I wouldn't be able to keep track of that, counselor.
Okay, so if I said over 500 decisions from courts that either alter its application, change its application, or uphold its application, you wouldn't have any reason to dispute that, would you?
No, I have no basis for that.
Okay, and just to be clear, you haven't read all of those cases and those various applications, have you?
No, there's enough cases that I have read.
All right, with respect to State v. White, do you recall when that case was decided?
I don't, counselor, offhand.
Okay, do you recall that it was a 2010 case? That incident happened in 2010?
I'll take your word for that.
Okay. Do you recall how many cases have cited that decision, affirmed that decision, disputed that decision, or had various applications of that decision?
In Erie, Ohio, no, I wouldn't know that.
Okay. Would it surprise you that it's upwards of 300 cases?
Based on my testimony and citing State v. White, I wouldn't be surprised.
Okay. And again, you have not read all of those cases and those various applications, have you?
No, I have not.
And since you rely so heavily on these cases and that there have been lots of applications of it, those cases, if those applications were different, or there are some varying applications of those cases, could that possibly change your opinion and analysis here?
I've testified in courts. And,
I'm sorry, sir.
Sorry, I'm answering a question.
You may be answering a question, but my question is yes or no. Would that change your decision?
That wasn't your question, but yes, that would change. No, not in the application of State v. White, but no, I don't know that.
So your answer is you don't know?
My answer is, in terms of the application of State v. White, no, that would not change.
All right. You also rely heavily on Officer Coy's statement, Mr. Coy's statement, don't you, in making your determination?
I do, yes.
So if there are things that are different in his statement versus what really happened, that could change your analysis, couldn't it?
Can you describe what really happened?
If there is an item in Mr. Coy's statement that is different than what you have, couldn't that have an effect on your analysis?
I've not been afforded the opportunity to review that, so I'd have to review the item and make a decision.
Okay. So it sounds like your answer is either yes or no, depending on the item that is different. Is that accurate?
Well, afforded the ability to analyze it, yes.
Okay. So it could have an impact on your analysis and decision.
It could, depending on the item.
Walking through your report, you stated that Hill posed an immediate threat to officers or others. Didn't you write that?
Can you refer me to a page and paragraph?
I believe page 12. I do not have a paragraph for you.
The topic area, in answer to your question, is examining the gram factors, whether the suspect posed an immediate threat to the officers or others. And my response was based on Officer Coy's perceptions as listed in his statement.
So I guess I'll ask you a more direct question. Did Hill pose an immediate threat to Officer Coy?
I believe that Officer Coy perceived and was reasonable in his perceptions that Mr. Hill did, yes.
Okay, so
He didn't ask you, was it a perceived threat? He said, did he pose a threat? Was there an actual threat, not a perceived threat?
you answered a question, but you didn't answer my question. My question was, did Hill pose an immediate threat to Adam Coy?
In hindsight, we know it was a set of keys, so no.
Okay, so your answer is no to that question.
My answer is, in hindsight, based on what we know after the shooting, that he did not, in fact, have a handgun.
Okay. Hill did not have a weapon, you recognize, correct?
That is correct.
And according to the defendant's statement that you relied on, Hill never made any intention that he was going to perform a violent act. Isn't that correct?
There was no articulated threats by Mr. Hill, no.
Okay. And Hill was not committing any crime, correct?
I don't believe so. I don't think
All right.
anything was.
Thank you.
No, he wasn't. But yet, you still want to say, after all that, answer them all them questions, you still want to sit here and say that he acted within his training and that it was okay for him to shoot him when it was no threat. He didn't make no moves towards him. He didn't come at him aggressively. He didn't rush at him. He didn't even raise his hands in a threatening way or none of that. So what was the point of the shooting? And then you're going to say, yeah, that's how they're trained. It's okay. If he perceived a threat, if he thought he was going to get shot, then it's okay as long as they think it. We can't go in their mind. We can't ask them what they was thinking. We don't know if he was on drugs or none of that. He might have been on mushrooms tripping, but we just got to go off however they was feeling. The fuck?
Another question for you. You had talked about, where was it? You had talked about the essentially three stages of police-civilian interaction. You talked about a consensual stop, reasonable articulable suspicion, and probable cause to make an arrest. Do you recall that?
Consensual stop, reasonable suspicion, probable cause, correct.
Can you talk about those again, please? Essentially define or tell me what they are.
Well, once again, officers in the performance of their duties come into contact with subjects every single day. Many of those encounters are consensual. An officer, say, is proactively, he's downtown and he wants to check out a subject that's bothering pedestrians, etc., like a panhandler. The officer can go up and say, excuse me, sir, can I talk to you for a minute? If the subject stops, that's a consensual stop. They can engage in contact. It can develop into reasonable suspicion or probable cause from there, but it's consensual in nature. If the officer believes that a crime has been, is being, or about to be committed, then the officer has reasonable suspicion. He can go up to the person and say, excuse me, I need to talk to you. And if the person tries to move away or walk away, then he can use force to detain him, all right? Based on his feelings that weapons may be involved, he can even do what's called a Terry pat down of outer garments for weapons. And then finally, if he observes the probable cause, that elements of the crime, that crime has been committed, then he can stop the subject, use force to detain him, handcuff him, and place him under arrest.
Okay. And none of the interactions between Adam Coy, Mr. Coy, and Andre Hill, was there a probable cause to make an arrest, correct?
I believe there was the probable cause to believe that Mr. Hill presented a threat of death or serious bodily harm.
Okay. Again, you're answering a question that I didn't ask. My question was, do you believe that there was probable cause at any point?
Objection, Your Honor.
Overruled.
Do you believe that there was probable cause at any point to arrest Mr. Hill?
I believe he had, as I said, probable cause to believe his life was in danger
Your Honor, I'm going to ask that you direct the witness to answer my question.
Okay, to the best of your ability, the question is, do you believe there was probable cause at any point to arrest Mr. Hill?
I didn't see elements of the crime, so no probable cause to arrest.
Thank you. And when we talk about consensual stops and a reasonable articulable suspicion, you talk about consensual from the officer's point of view. That's how you've described it here in this courtroom today, correct?
Well, that would be whether the subject consented, so it would be the perception of the officer and the subject's behavior or statements.
Is a subject allowed to walk away from a consensual encounter with a police officer during a consensual stop?
Yes, as I stated before, if the officer doesn't have reasonable suspicion or probable cause, then the subject can walk away.
Okay. They can end that conversation and walk away. Is that correct?
Correct.
No individual has an obligation to talk to police officers on a consensual stop basis. Isn't that accurate?
On a consensual stop? No.
What about reasonable suspicion?
As I stated earlier, reasonable suspicion that a crime has been, is being, or about to be committed, then the officer can use force to stop the subject.
You stated in your report and also in testimony here today that the importance of watching an individual's hands. Do you recall that questioning from defense counsel?
I did, yes.
Okay, so you would agree that it's important if an
It's his spirit animal. His spirit animal came in and showed up to show him some support.
officer is concerned that an individual may have a weapon, that an officer is to watch the hands.
Yes, I think that's for officer safety, which is paramount in these encounters, that the officer watch the hands to the degree that they can and control the suspect's movement.
And also, I guess, added to that, if an officer wants to see an individual's hands that they can't see, an officer can simply ask to see their hands. Isn't that correct?
Ask or order, depending on the circumstances, yes.
All right. You also stated in your report on page 19 that when confronting an individual, police officers are taught to maintain as much of a reactionary distance between themselves and the person as feasible. Do you recall writing that?
Yes.
Okay. Why is that important, Mr. Davis?
Well, to the degree possible, oftentimes officers are responding to a subject's actions. They can't control the subject, and we teach the reactionary gap as much as possible to maintain a safe distance away from a subject to give them time to be able to respond should an assault occur.
Okay. And that reactionary distance is dependent on the facts and circumstances, correct?
Correct. If, for instance, the officer is confronting somebody with a long gun, like a rifle, that would be as much distance as the officer can manage. If, in other circumstances, handgun, once again, further distance, but just dealing with subjects on the street, the average reactionary gap, as we teach in the basic academies, is about 6 feet.
Okay. So you talk about also that the video that the body-worn camera that you viewed of the shooting and killing of Andre Hill is not, I guess, accurate to what Mr. Coy saw, correct?
Oh, that's absolutely true. Yes.
Okay. And you indicate that the video may actually have better lighting, lighting enhanced. Is that correct?
Well, there's two different videos. There is this just a basic unedited BWC video from Officer Coy. That has increased light capabilities more than Officer Coy's eyes. And the OOIC video has specifically been...
Yeah, my bad. His voice is hella low. I'm trying to cut it up as we go, but sometimes I'll be in the midst of doing something else. Appreciate y'all being here. Hit that like button. Hit that subscribe. Tap in. Share with a friend. We almost up out of here for the night. Appreciate y'all. How we get to 320? Wait a minute. Did I skip some?
enhanced.
Oh, no.
Okay. Speaking of body-worn camera, according to generally recognized police practices, back in 2020, when should an officer turn on their body-worn camera?
It depends on policy and procedure of the agency.
Okay, well, I'm not talking about policy and procedures. I'm talking about generally recognized police practices. So are you saying that were none?
There's really none in terms of body-worn cameras. Since then, there's a multitude because of the
Thank you, Mr. Davis. You've answered my question. I'm going to move on to the next question.
What up, Miss DB? He said,
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
Okay, hold on. All right. Let the witness finish responding to the question that was asked.
Because of the large amount of interactions that officers have with subjects and the amount of digital video evidence that's being produced from these cameras, agencies throughout the country have applied different things. Some agencies, when you first get the call, you turn it on. Some agencies, when you get out of the car, you turn it on. Some agencies, when an arrest is being made, you turn the camera on. So there's a multitude of different, BWC policies. There's no standard.
Okay. You go on to define danger cues, I believe on page 36 of your report.
Refer me to a paragraph, Counselor.
I do not have a paragraph, sir.
The evidence is going to show that anything that I may have said, they exacerbated it.
Lady Justice is blind. Everybody can get it.
Okay, so you teach your officers that, the officers that you teach, you talk about danger cues, correct?
Danger cues are yes, but more than that. There are different types, body postures, precept body attack postures, etc. So yes.
Okay, so walking toward an officer could be a danger cue.
It could be, depending on the circumstance.
Walking away from an officer could be also be a danger cue, correct?
Yes, I would say yes.
I guess keeping your hands concealed could be a danger cue.
It could be, depending on the circumstance.
Walking away from an officer could be also be a danger cue, correct?
Yes, I would say yes.
I guess keeping your hands concealed could be a danger cue, correct?
Certainly, as we talked about, hidden hands.
So showing an officer your hands could be a danger cue, couldn't it?
Quick movement of showing the hands.
Move for
Depends on the time and circumstance.
Okay. Looking away from an officer could be considered a danger cue, couldn't it?
Called furtive glances or looking away, looking for other subjects, looking for other officers, looking for means of escape, so yes.
Looking at an officer can also be considered a danger cue?
Depends. I mean, people look at officers, but...
So basically, everything you do is a danger cue. They can use anything, any movement. If you open your hands, you close your hands. Lift your hands, lower your hands. You go in your pocket, you don't go in your pocket. You look at them, you don't look at them. Anything you do can and will be used as a trigger for them to kill your ass.
It's called the 1,000-yard stare. It can be considered a danger cue, yes.
Okay. Talking to an officer can be considered a danger cue, correct?
I don't know that I've ever heard talking to officers as a danger cue.
Well, Mr. Davis, you reference in your report that it was a cue that Mr. Hill spoke to Officer Coy before Coy addressed him as a potential danger cue, didn't you?
Where are your police reports?
That would be the right front, the right left, excuse me, the right left side. Front.
Okay, all right.
I don't remember what I said, but I was high every day for a whole year, and I was at anything. I was at and done anything to get out of here. I was at and done anything.
I don't think that was used as a danger cue perspective at the original stop. I think it was part of Officer Coy's development of reasonable suspicion in the totality of the circumstances, but no danger cue, no.
Okay, but you do agree with me that you indicated it was appropriate for Mr. Coy to take that into account as to something being out of the ordinary, the fact that Mr. Hill spoke to Mr. Coy first.
I think that was part of Officer Coy's statement to be considered in totality of the circumstances.
Can you think of anything that could not be considered a danger cue? Anything of natural human movement that really could not be considered a danger cue under any circumstances?
We deal with subjects on the street all the time, natural human movement, and no threat is perceived.
Well, if you look like me, buddy, and you talk like me, and you walk like me, buddy, I don't perceive that as a threat. Fuck out of here.
And no danger cue is felt, but they have to be viewed in context, and they have to be viewed in the totality of the circumstances.
So would you agree with me that natural movement should not be considered a danger cue?
Depends on the circumstances. It can be based on the context.
Okay, so you would agree with me that natural movement can be considered a danger cue, correct?
Well, the officer wouldn't know. He would be going like danger cues or cues of pending danger to the officer, and that has to be perceived by the officer based on the totality of the circumstances and his reasonable perceptions.
You talked about threat, correct?
Can you refer me to a page?
I believe on page 39, you state a threat is capability to do harm joined by hostile intent.
That's a quote, but yes.
Okay. Do you accept that quote, or do you dispute that quote?
I believe that intent is hard to determine by officers because what we have is instead perceived intent, what the officer believes based on the circumstances. So capability can be based on the circumstances as well. So I have quoted that author, and I do not believe that that's unreasonable.
What is a threat according to you, Mr. Davis?
Well, that would have to be perceived by the officer, and depending on the circumstances. Different threats can be.
That's a good question right there. And actually, shout out to No One. We just covered that topic. The difference between a threat and a warning on the Rock Solid channel. Video will be released soon. We working on it, you know, in our spare time. It ain't very often. We recorded a while ago, but it's dropping soon. It's about to be heat. Y'all check it out. Appreciate you, family. Go sub up to Rock Solid TV.
Different, I mean, everything from cocking the arm back to, you know, the threat of a punch to suddenly reaching inside the waistband to lifting the arm up quickly. All those can be perceived as threats based on context.
So it's up to the own individual officer to determine threat.
It is, yes.
A couple more questions, Mr. Davis. You would agree with me that an officer can be mistaken, but also operate or be operating outside of generally recognized police practices, correct?
I think those circumstances could exist hypothetically, yes.
Okay. So just because an officer made a mistake does not mean that they are operating within generally recognized police practices, correct?
Hypothetically, again, yes.
You wrote on page 44 of your report talking about perceived danger. and I wonder if this is a quote that you just used or a quote that you agree with, and I'll read it for you.
Please.
The perceived danger
It's my time. It's my time.
must only be apparent, not an actual danger, in order for the officer to use lethal force. Do you agree with that?
Yes, I believe if the officer believes that his life or the life of another is being threatened, then yes, he can respond with deadly force.
Okay.
License to kill. They can shoot your ass legally and get away with it and feel like they did nothing wrong. They say they did nothing wrong. They can walk to that scale at the end of their life and put their heart up against that feather, and they ain't gonna feel no bad way about all this killing they did. They shit gonna be right there balanced because they think they doing the right shit. Y'all following the wrong rules. They don't need forgiveness. They heart is light. They think they doing the right shit. That shit ain't gonna work for them, no. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. We almost up out of here.
You also wrote that on page 29. Clearly, Officer Coy's tactics were within best practices in law enforcement. You agree with that? Is that your statement?
I do.
I heard you say earlier that the term generally recognized police practices is not something concrete. Is that right?
Because of the large number of agencies, every state has a training, like Ohio, we have the Ohio Peace Officer Training Commission. They develop curriculum in the training of officers. Every state has some version of that. Every agency has different policies. Every agency trains differently. So I believe trying to come up with national police standards is tough.
Okay. Looking at an officer who has used deadly force, they can be remorseful but still be operating outside of generally recognized police practices. Remorseful has used deadly force. They can be remorseful but still be operating outside of generally recognized police practices, correct?
I think that's correct.
Thank you.
Ain't your money.
No further questions, Mr. Davis. Thank you.
Thank you.
Ain't your money.
Thank you, Mr. Pearson. Redirect.
And y'all pay for this. This out of taxpayers' money, right? So is it crazy like that people are forced to pay taxes? Like, should you be forced to pay taxes for some stuff like this? For this type of bullshit? It's all just a bunch of bullshit, isn't it, really?
The absence of evidence is not the evidence of absence.
What?
Drop some coins and some witch emojis for Chan My Black is Golden. Appreciate you, family. Chan My Black is Golden and Joni Ford, stream sponsors of the night. Appreciate y'all for the gifted memberships. Y'all show them some love. It ain't your money. That nigga wildin'. It's taxpayers' money. It is your money. Crazy.
It ain't your money.
Appreciate y'all, though. Y'all show them some love. We almost about here. Much love, much love.
May I inquire?
You may.
Thank you. Mr. Davis, Mr. Pearson asked you about Graham v. Connor. Do you recall that?
Yes.
Is Graham v. Connor still the standard by which officers are permitted to respond with deadly force?
Yes and no. in some states, for instance, Virginia being one, I've worked on cases in Virginia, although Graham v. Connor is taught in the basic academy there, in some courts, they believe it's a civil case, and so it doesn't apply to criminal matters.
Here in the state of Ohio, is Graham versus Connor still the standard by which officers are permitted to respond with deadly force pursuant to nationally recognized police practices?
That in Tennessee versus Garner, yes.
Is State v. White still the standard by which officers are permitted to use deadly force when responding to a suspect that they perceive a deadly threat by?
Yes.
Are officers still trained on State versus White?
Depending on the agency, less so in State v. White, unfortunately.
Here in the state of Ohio, are officers still trained on State v. White with respect to mistake?
Objection, Your Honor. Broad generalization.
Okay. Overruled. If the witness notes.
It's now become part of the basic academy curriculum in the state of Ohio.
Are Graham and White consistent with nationally recognized police procedures?
Yes.
Mr. Pearson talked about whether the suspect posed an immediate threat. Do you recall that conversation?
I do, yes.
What are actual threats versus perceived threats?
Well, actual threats would be the suspect turns out later on to have a gun, whether the gun is recovered after the shooting or is fired at the officer. A perceived threat is up till that point, and that's determined afterwards. If no shots were fired and a shooting occurs, then we would find out that it was a perceived threat, but not an actual threat.
If an officer sees an arm leveled in their direction and they see the glint of steel, how are officers trained to respond?
Based on their perceptions of the threat of death or serious bodily harm, they're trained to respond with deadly force.
Does a person have to have a weapon in order to respond with deadly force?
In order for an officer to respond?
Correct.
No.
Why is that?
Because the officer is acting based on his perceptions. We have to look at whether those were reasonable perceptions based on the circumstances.
If an officer perceives a suspect coming at him with a hidden hand, can they perceive a threat there?
They can, yes.
Is that a danger cue?
It is, yes.
Is that a threat pattern that you train officers to look at in the academy?
Absolutely.
Mr. Pearson talked to you about probable cause to believe Andre Hill was committing a crime. Do you recall that conversation?
I did, yes.
Did Officer Coy have probable cause to believe that he was going to be shot on December 22nd, 2020?
Based on his statement of his perceptions, yes.
Was there a perceived deadly threat there?
Yes.
You recall the conversation Mr. Pearson had with you with respect to reactionary distance, correct?
That is correct.
Any issue with the reactionary distance that Adam Coy took here?
Have a good night.
Why is that?
Have a motherfucking good ass night.
Closing in within that 6-foot distance, and Mr. Hill was the one that was moving towards him.
You had a conversation with Mr. Pearson about mistake. Do you recall that conversation?
I do, yes.
What did you find with respect to mistake here in this situation back from December 22nd of 2020?
That.
Hold on. Look, Johnny Ford, that's the crazy part. They trying to lie and say that they saw keys in his hand, and that's the reason why they shot. But in the video, I'll play the video too before we roll out. He didn't never take, his hand was in his pocket, so he never saw no keys. The reason they saw keys after they shot him, and when he dropped his hand on the ground, when he fell on the ground and took his hands out of his pocket, they found keys like on the ground. They didn't find no gun. That's why they said it was keys. But he didn't see no keys in that freaking video before he shot him. My bad, but yeah, appreciate you, Johnny, for it.
It was a mistake of fact shooting, that Mr. Hill did not have a gun.
And what did you find with respect to whether that mistake conformed with nationally recognized police practices and procedures?
Based on the facts, including the body-worn camera and Officer Coy's statements, that it comported with those national standards.
Thank you, Mr. Davis. I have no further questions. Oh, I apologize. Hold on. That's what I get for not asking. If I may have them on. May I have them on, Your Honor?
You may.
Man down. 11:30. Hip in distress.
Is one of those facts that you took into consideration based on the fact that you saw pictures of a silver keychain at the scene back on December 22nd of 2020?
I'm sorry, one of the decisions that I factored in, or one of the facts I factored in? Yes, yes,
with respect to the mistake?
yes.
Thank you, Mr. Davis. I really do not have any further questions right now.
Thank you, Ms. Stevens. Recross?
Yes, just have a very short follow-up. Mr. Davis, you talked about a perceived threat, and you indicated that anything the officers say they were threatened by. Wouldn't that be a perceived threat?
Would be based on the facts and circumstances, yes.
Okay. And if an officer perceives a threat, they can use deadly force?
The determination is based on they have to have probable cause to believe that their life or the life of another is threatened with death or serious bodily harm. So if they reasonably perceive that threat, then yes, they can respond with deadly force.
Okay, you inserted a word there that I did not have previously inserted. That interpretation must be reasonable, correct?
It's based on, an officer's decision is based on our perception of whether his perceptions were reasonable based on the totality of the circumstances, yes.
Thank you. No further questions.
Thank you, Mr. Pearson. All right, Mr. Davis, you can step down, sir.
Thank you, Your Honor.
So it's no sound in the beginning until after he shoot him. Then he cut on the sound. This is just the minute before you start the body cam, where it records the video but no audio. So this is 1 minute before the body cam actually starts. And they already talked to this dude. This is not the first time. Like they already been there tonight. They were already waiting on him. Like, it's crazy. Like they act like this is their first approach, but it's not. They were already talking to him. They already know he wasn't a threat. They already know he didn't mean them no harm. He wasn't in no danger or you know, causing no danger. And look. He's showing them, I got the, oh man. He showed them the phone in the hand. Look, he got his phone right there in his hand. Let me blow it up for you. Hold on, let me blow it up for you. Hold on. Hit that like button, hit that subscribe, tap in. Let me blow this up for you one time. Dang. All right, here we go. Oh. Got the phone in his hand. All right. Look, his hand is down. His hand is in his pocket or down to the side. You can't see what's in his hand. So it's no reason for you to feel threatened. It's just like, oh, I can't see your hand. It must be a gun. Gun, shoot, because I can't see your hand? No, that's not how it works. I'll even slow it down. Here, let me rewind it and go in slow speed so we can see what happened. Here we go, slow speed, super slow. No type of movements, no hand lifts, no nothing, no keys that they talk about they seen, none of that. That's insane, family. And then he just now about to turn the body cam on a fucking hour later. Beep, beep. Oh, I think I got it on mute. Look, this is where he turned it on. You can hear it. Watch him put his hand down, turn it on right here. Beep, beep.
Put your fucking hands out to the side. Hands out to the side now. Roll to your stomach now. Yeah. Hey, don't get fucking close. I can't see his fucking hand. Get your hand out from underneath you now. We got a medic coming. Don't move, dude. Fuck. Roll over, dude.
Okay, look, and now I'm gonna keep it playing. You could hear one of his daughters talking though. You could hear his daughter saying he didn't do nothing. She just said that. I'm gonna rewind it and turn it up a little bit.
Any additional? Copy. 3031, copy, get ready to pull up.
Get me support.
Okay.
No assistance. You hear him over here struggling to breathe. No assistance. You obviously not threatened. You ain't putting no handcuffs on him yet. You walking over him, walking back and forth, walking around. Like, you ain't even gonna try to help the dude? That ain't part of this training, this super training y'all was talking about? All this, oh, we train all overseas. We do so many training, so much training. But this ain't part of your training? Your training is to shoot a nigga and let him die? That's your training? Fuck out of here. And look, now it's getting to him. It's all messing with his stomach. Now he over here coughing and spitting up like he the one dying because that whatever that soul transfer is, like you just got accepted into whatever organization you was signing up for. You got your black heart. You got your teardrop, whatever it is, your ace card. Crazy. Now listen to him. Sorry about the sounds. It's gonna get a little disrupting, but I'm gonna let it play so y'all can hear really how distraught he sounded about killing this dude, knowing he was wrong.
assistance here. Let's fuck him up.
You better not ignore those bars there, please.
Asistencia acá en esta playa para Messi, 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 encara 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 Messi.
Hey, no one. I don't think he was acting. I think he was either high, or this just was the effect of that first catching that first body, and his body didn't know how to react to it. He couldn't really take it, so it fucked him up for catching that first body, and he just got instantly sick. Or he know he was wrong, and his stomach, like Chan My Black is Golden said, his stomach is in there knotted up and tying in knots right now, so it's spitting up everything. And option 3 is that he was high, and I think that might have been part of it too, as we gonna see coming up when he grabbed his stuff out the car. I'm gonna let it play up to that point when he grabbed his stuff out the car. I think he was high, and then just being high like that, once something mess up your high, it could tear up your stomach and make you react like this because of your reaction to the high. You know what I'm saying?
I don't know what I said, but I was high every day for a whole year, and I was at anything. I was at done anything to get out of here. I was at done anything.
Let's get out of here. Come on. Come on.
That's the movie in route.
So this is the suspect part right here. He gonna tell the cop, oh, I'm just trying to think of what I missed. I'm trying to think of what I missed, so that the cop could walk away and not show on the body cam that he grabbing some stuff and about to hide some of his evidence or pills or whatever, which I think again is him covering up that he was high. Miss DB said those donuts trying to come up. Facts.
I'm gonna throw the bag in the back, or we'll just go down the end of the road, okay? You can talk to whoever you want to talk to down there, right? You got your phone with you?
Yeah. Okay. Gotta figure out what I missed.
Huh? We'll take care of that, I promise you. We're gonna say anything about that right in a second. Yeah.
Okay.
I'm gonna throw the bag in the back, or we'll just go down the end of the road, okay? You can talk to whoever you want to talk to down there, right? You got your phone with you?
Yeah. Okay. Gotta figure out what I missed.
Huh? We'll take care of that, I promise you. We're gonna say anything about that right in a second. I'm gonna go throw my stuff in the back, okay?
Okay.
Good? We'll come back for this. We're just gonna head down the road. Let's get you out of here for a second.
We got any bosses here?
No, yet. Sarge's on his way. Yeah, we'll air it and he'll come down there and talk to you.
Man, that's the definition of Rico. That's exactly everything Love and all them attorneys been fighting for and claiming. RICO, that's exactly what this is right here. Y'all covering up for crimes, protecting, and a dude on the stand too. That's all RICO. That's the definition of RICO.
I'll call Sergeant. You can look at these shut off right now.
Yeah, that'd be nice.
415, this is Dean Secure from that incident.
What the hell you smoking? It sound like you inhaling something, like you hitting a blunt or something. You breathing that hard?
All these flashlights and all that whatnot. We're just going on the other road if you want, man. I know you're kind of... What do you want? Hey, listen. What do you want?
Let's just walk over there.
Okay, if that's what you want to do, man. I'm just here.
Let's just walk over there so I could drop these pills in the grass. Empty out this powder bag.
Go ahead.
Well, kings, queens, gods, human beings, and everything in between, welcome back to Flesh of the Gods. The God Shango here. Today, we continue our journey into the heart of the justice system's inner workings. We've witnessed the tears of a grieving family, and we've analyzed the testimony of Officer Amy Detweiler, a key witness that helped lead the guilty verdict for Adam Coy in the murder trial of Andre Hill. Today, we peel back another layer. We now face a new form of deception, one cloaked in expertise and credibility. We turn our attention to former Officer Kevin Davis. Davis was once a SWAT team lead instructor, training officer, officer here, officer there, SWAT, all types of stuff. This is a man who also taught police the very rules of engagement, and he was brought in as a paid expert witness. But here's the truth that cannot be ignored. Kevin Davis was paid $250 an hour for this case. That's right, family. I said $250 an hour. And his sole purpose was to justify the unjustifiable murder of Andre Hill. He was a hired gun for the system, basically. Seems to be brought in to create a legal shield for a convicted murderer who, to this day, still believes his actions were justified and is appealing his guilty verdict. This episode isn't just about a trial. It's a re-examination of a system that will spend thousands of dollars to defend a lie. We will watch and analyze Davis' testimony, questioning the very definition of expert, as in their expertise is for sale. What kind of truth can be found when it comes at an hourly price tag? But before we begin, remember that all the video and audio clips used are part of the public record and are used for the purpose of analysis and commentary. If this journey into the truth resonates with your spirit, please like, subscribe, tap in, and share with a friend. Stay vigilant, stay fresh, and stay blessed. Let's get it started, family.
The absence of evidence is not the evidence of absence.
What?
Yo. Big shout out to our stream sponsors. Joni 4, Chan My Black is Golden. Appreciate y'all, family. Shout out to No One. Y'all go sub up. Shout out to Rock Solid TV. Go sub up. We got some stuff coming soon. Brown Sugar Babe. Appreciate you, family. Joni 4. Appreciate you, family. Let's see. Miss D. B, Miss DB, I see you. I appreciate you, family. Miss D56, I appreciate you, family. Shout out to Late Night Bacon with Mookie Mookie. Y'all go sub up. TikTok and YouTube. Go sub up to Late Night Bacon with Mookie Mookie. FFS, I see you, family. Appreciate you. Tat Clouds with the new logo, the Kali. Just the Kali. God is Kali. Dope stuff. Brown Sugar Babe. No one. All right, that's all doubles. Late night. Daniel Berry Sports highlights came through. Appreciate you, family. And shout out to all y'all. And other than that, we going to keep it going later. I just wanted to come and check in with y'all and keep this rolling. You know what I'm saying? We've been out here on this this Adam Coy trial thing. So anyway, I just wanted to say what's up to y'all, man. Shout out to all y'all. Shout out to our stream sponsors. Much love. Stay fresh. Stay blessed. And peace out. I'll see y'all either Thursday or Saturday. I'm not sure when. Either Thursday or Saturday. Peace out, family.
He arose, never hated friend or foes, just a sub to art and not giving a fuck. Chasing down my goals, I self-law am master, supernatural disaster, metaphysical reactions. I am the flesh, I am the God. No one at the lab on lockdown. Denied. Cold summers, black force ones when we slide in the streets. We all stay home at a club jumping. What up, cousin? I see you, fam. Throwing slime corns when I watch the trial. LEOs be capping, chatting action. Come and tap in the most interactive. I am the flesh. I am the God. I am the flesh. I am the God.
Lock every leg, gon' tap in. Gon' play skin, every rap in. If you like us, gon' get the lights up. You sub, you can share, tell them pack in. From the left, right, front to the passenger side. It's right here, the premiere. How you know? Cause them boys broadcast to the live. Wanna talk about it, hit the link right here. Slide coins up, got 100 bands. Mars eyes, watch how the check. And the band made love to a bobblehead. 2 bands do a dance like check. I'ma keep going till I'm motherfucking tired. You what? I'm motherfucking tired. Slide brother side, could we rain down game? Like, what you mean? Just watch the rise. Watch the rise.
I am the flesh. I am the God. I am the flesh. I am the God. Flesh of the God.
Peace, love, and joy, Joni 4.